Hello, friends of the IACL blog, and welcome to another interview in our series highlighting recently published books. And I'm delighted to be joined today by Rehan Abeyratne to discuss his new book, Courts and LGBTQ+ Rights in an Age of Judicial Retrenchment, which was published by Oxford University Press a couple of months ago in April this year. Welcome, Rehan.
Thanks, Lizzie. Great to be here.
Congrats on the publication of the book, which I have a copy here. Very beautiful. All right, so I'll just briefly introduce Rehan in the book, and then I have some questions. So Rehan is a professor and the Associate Dean High Degree Research at the Western Sydney University School of Law, teaching and researching in public law and comparative law. And in this new book, he tackles the question of why the constitutional rights of historically marginalised LGBTQ+ people are expanding, while liberal constitutionalism is in decline, focusing on this question in the context of the decisions of apex courts in the last few decades and in three jurisdictions: the United States, India, and Hong Kong. So, Rehan, to start off with, can you tell us a little bit about why you decided to write this book? And sort of as a sub-question, given the shifts in governments and courts we've seen since you probably started writing it, whether that motivation shifted at all?
Sure. Well, thanks again, Lizzie. It's great to be here. So just a little bit of background as to why I started writing the book. It actually came out of, I think, an observation from teaching. So I was teaching at the Chinese University of Hong Kong from 2017 to 2023, which coincided with the mass protests there in 2019, then the subsequent authoritarian turn and constitutional overhaul that took place in Hong Kong, and I think is pretty well known. And throughout that period, I was the course leader for both undergraduate constitutional law and postgraduate comparative constitutional law. And especially for undergraduate constitutional law, it was just an incredibly challenging time to teach because the syllabus changed every year, not just in the usual way that new judgments come out and you have to update the cases, but that fundamental values, things like separation of powers or judicial review, became so detached from their original meaning or so defunct that I had to completely overhaul how they were taught. And yet at the same time, there continued to be incremental progressive development on LGBTQ+ rights in Hong Kong. And this also deserved attention, especially because the petitioners and the lawyers representing them were bravely holding the torch of liberal constitutionalism in this otherwise dark period. So this observation that LGBTQ+ rights remained the only area of progressive growth for constitutional rights for the authoritarian turn in Hong Kong sparked a broader interest in me in the ways in which LGBTQ+ rights are used by courts in societies where liberal constitutionalism is in decline. So in 2020, I got started on this. It led to a 5-year-long project that culminated in this book. And then in terms of your second question about motivation, I think I originally saw the project more as focused on LGBTQ+ rights as an interesting and potentially final chapter of global constitutionalism. And while that's still covered, I think the book in its final form became much more about the work that these rights do for authoritarian-leaning regimes and for courts who find themselves in increasingly hostile political environments for liberal rights protection. So I think the book went from being a little bit more transnational in scope to a little bit more focused on the domestic politics of these three jurisdictions.
Oh, and I guess leading on from that, my next question was, what do you hope to see as the book's main contribution? It sounds like that's a bit of what's changed. And then related to that, who do you think are the key audiences for the book? Who do you want to read?
So, the book starts with a big question, which is, and I think I've hinted at this already, which is, how can it be that liberal constitutionalism is in decline in these societies while the constitutional rights of a historically marginalized and disfavored group are expanding? And so the book's main contribution is to help us understand that paradox. So that's the coexistence of liberal constitutional regression on the one hand, and court-led progressive developments on LGBTQ+ rights on the other hand. And then to explore a little bit about what that might tell us about the state of global constitutionalism. As you said in your intro, it does so through the analysis of 3 case studies. the United States, India, and Hong Kong. And I argue that courts in these societies have used LGBTQ plus rights adjudication strategically to pursue one or both of the following objectives. The first is to sustain a progressive rights agenda with minimal political backlash. And the second is to preserve what's left of the court's reputation, and in some cases, the individual judge's reputation, for independence and commitment to fundamental rights in this era of liberal constitutional decline. So I build and substantiate these arguments in the book's three main chapters, chapters 3, 4, and 5, which are devoted to the United States, India, and Hong Kong, respectively. In each of these chapters, I'm trying to show first that my descriptive claim is accurate, that is, LGBTQ plus rights, or at least a subset of these rights, are in fact adjudicated more progressively than other constitutional rights. And then I'm trying to provide a context-specific account of the strategic factors that account for this discrepancy in each society. So the specific form, application, and time span of these strategic objectives is deeply contextual, of course. It varies a lot among the three case studies, and I try to bring that out, or try to bring out those differences in each of the main chapters. One point of commonality, though, which I should mention, is that I argue that there's been a shift towards the second strategic aim over time. That is, more recent LGBTQ plus judgments in all three societies move from being predominantly about global constitutionalism and preserving that, or liberal constitutionalism and preserving that domestically, towards what I call self-preservation. And so I argue that these judgments serve primarily as rhetorical devices to demonstrate a judicial commitment to liberal constitutional values, even when their judgments do little to advance those values in practice. And finally, just in terms of audiences, I mean, I think, you know, it's definitely an academic monograph. So I think the main audience would be the folks working on comparative constitutionalism, folks working on constitutionalism within these three societies, and then hopefully also the book contributes something to the literatures on LGBTQ plus rights and on democratic decline. And I hope that it'll be read by people in those subdisciplines too.
Right. Yeah, and I think you achieve, in my view, you've achieved those two objectives, and I think raised some really interesting questions at the end as well about the normativity of self-preservation, which is of great interest in the democratic decline space. So I wanted to probe a little bit deeper on case selection. I often ask these questions in these interviews because I think, you know, one of the trickiest things about putting together projects like this is figuring out and then justifying case selection. And I think you do it very well in the book. But I think it would be helpful if you could just briefly explain for the audience, well, not today, but in the in the near future, your choice of the three jurisdictions, and also if you have any reflections on the, you know, undertaking the kind of detailed, granular research that you need to undertake for the level for these kinds of case studies. So again, sorry, a bit of a two-parter, but
yeah, no, it's great. So yeah, on methodology, you know, I adopt an approach that Rand Herschel has called concept formation through multiple description. And so just use his language here. So he says this approach seeks to generate analytical frameworks for thinking critically about constitutional norms and practices by focusing on a single practice as carried out by different jurisdictions. And if you sort of zoom out a little more and sort of look within the broader discipline of comparative law, I've adopted a functional approach, which I think is the primary approach that most comparativists take. And that involves identifying legal rules that perform a similar function across case studies and compares how those rules operate or fulfill that role in each context. So for this book, I was looking for case studies in which LGBTQ plus rights play a similar legitimating role for courts whose constitutional jurisprudence is regressing in other areas. So I chose case studies that have baseline similarities that enable meaningful comparison while maintaining sufficient diversity to add to the richness of the study. So I think the US, India, and Hong Kong, as a set of three, achieves that. So what do they have in common? Well, they all have common law legal systems, they have strong form judicial review, and they have a threshold level commitment to liberal constitutionalism, at least they did up till a few years ago. They also have experienced backlash in various forms against liberal constitutionalism and against sort of judge-led developments on constitutional rights, and these courts have had to adapt accordingly. But they're also distinct in important ways, which I think should be noted, right? So of course they're geographically distinct. One in North America, one in South Asia, and uh, one in East Asia. There are different kinds of courts. So the US court is very attitudinal, right? The individual views of the justices matters a great deal to judicial outcomes. The Indian Supreme Court has been called instrumental, right? So law is used towards an end. So it's very much about the end and not about the process. And the Hong Kong court is a more traditional kind of common law court, more collegial, more circumspect, much more sort of incremental in its approach. These courts are also responding to different sorts of pressures on their jurisdiction and on liberal constitutionalism in their jurisdiction. So in the US, for me, the primary concern is political polarization, which has then found its way to the judiciary, right? So one of the things I point out in the US chapter is that, it's not just that the US Supreme Court justices themselves are in an environment that is polarized, but they are actually actively contributing to that polarization, right? And I think that's an important part of the story. In India, it's a kind of Hindu nationalism or ethno-nationalism, which has led to restrictions on minority rights, especially for Muslims. And in Hong Kong, it's the prerogative of national security, especially since the protests in 2019. So those are the reasons, I guess, that I chose those three. And maybe I'll say a little bit about why I didn't choose some other jurisdictions. So since I'm interested in jurisdictions where courts do much of the heavy lifting on LGBTQ plus rights, I excluded countries where advancements in this area came primarily by way of legislation, which is true for much of Europe, or by referendums, like same-sex marriage in Australia. I really wanted places where the courts were doing the work. And since the book relies, among other things, on comparative doctrinal analysis, including an assessment of how individual justices appear to be balancing strategic considerations, I did not take into account, or I did not include case studies like Taiwan, where there is judge-led or court-led progressive developments in LGBTQ plus rights, but the legal culture is just very different, right? So in Taiwan, due to the civil law system and the formalistic legal culture there, the judgments are pretty short and technical. They're unsigned, not attributed to any particular judge. And so it's just difficult to sort of compare that to the much more personalized jurisprudence you get in the three case studies that I selected. And then finally, and this goes to the second part of your question about the granular contextual approach, I think aside from all the reasons I've just put forward for my case selection, I selected jurisdictions that I felt that I understood pretty deeply, both at a legal and political level. They're just saying, I'm not sure who it's attributed to, that all books are biographical, and if that's so, I think this book is especially biographical. I've lived, worked, or studied in each of these places for many years, which enabled me not only to have a good handle on the academic literature, but also the legal culture and I guess you could even say the vibes that I think are also an important part of this story.
Awesome. Yeah, and I think that leads nicely into my next question, which is really the point that, as comparative constitutional lawyers, we're in this joint enterprise of knowledge production, and we each bring to that what we know. And what I wanted to ask in that vein of the joint production of knowledge, and it's a hard question and it's maybe slightly unfair, but whose work was especially influential for you in writing this book? I say unfair because obviously it was many, and I'm asking you to.
Yeah, no, it's definitely a tough question. I'd say especially for this book compared to even other things I've written, just because it draws on several strands of literature and then many country or jurisdiction specific sources. So I can't do justice to everyone, or everyone that I've relied on or learned from, but I'll mention a few. So first, there's just the leading scholars in the field from whom I've learned most of what I know about judicial review and comparative constitutionalism generally. This includes folks like Rawls Dixon and Mark Tushnet, who I think are the two most cited authors in the book. On this topic specifically, I found Lawrence Baum's work on judicial audiences especially helpful in conceptualizing strategic incentives for courts. In the context of the US Supreme Court, he talks about each justice as having a personal audience, which I found helpful. And I think that applies to other jurisdictions too. So certain judges like Chief Justice Chandrachud in India and Chief Justice Ma in Hong Kong, I think also have personal audiences, including international media and certain transnational elites. And I use that conception to try to explain some of the LGBTQ plus case law that these jurists produced. Lisa Duggan's work on homonormativity helped me think through some of the effects of judicial decisions that may appear quite progressive, like those recognizing same-sex marriage, but have the effect also of mainstreaming and domesticating queer politics and defanging some of its radical potential. This dynamic, as I point out in the book, applies not only in the US, which is what Duggan wrote about, but also to India and especially to Hong Kong. And finally, I would point to the work of folks like Diane Otto and Eyal Gross, who have developed the term pinkwashing in the public international law literature, right? This is the practice of governments pointing to progressive developments in LGBTQ plus issues to obscure rights violations elsewhere. And so that I found useful in helping me think through the normative implications of these cases and the kind of self-preservationist tendencies of these courts. And in the concluding chapter, I note that I think the courts in all three jurisdictions were engaged in some form of pinkwashing, but I then go on to discuss how this practice might be more normatively defensible in some contexts than others.
Cool. It's always great to hear, just like what we build on and what we're contributing to. So I had two final questions. So that are more, I guess, about you. So what were the main challenges that you faced in writing the book? I think you've probably touched on a number of them already, but was there anything in particular you wanted to reflect on?
Yeah, there are a couple of personal things and a couple of things that happened in the world. So, I started the project in 2020. So, of course, COVID happened, which definitely delayed things with lockdowns and so on. Our second child was born in 2021. So, both of these things delayed my writing. But I actually think that worked out pretty well in the end, in that I was originally supposed to finish this book in 2023, but two really important cases, which are the same-sex marriage cases in India and in Hong Kong. So that's the Supriyo case in the Indian Supreme Court and the Shamsa Kit case in Hong Kong, actually came out at the end of 2023. So by delaying the publication of the book, I was able to work in those cases and I think make a stronger argument. It did involve a lot of extra work because I had to basically rewrite large parts of both of those chapters, but I think that all worked out pretty well at the end.
Cool. And then the last question was just if you could tell us what's next for you in terms of your academic projects.
Yeah, so I think if you plot academics on a spectrum, from one end, people who write on a few things in tremendous depth, and at the other end, folks who span a broad terrain and hop between different areas, I'm definitely closer to the latter. So I really enjoyed this project on LGBTQ plus rights, but I'm ready and in fact already have moved on to different things. Maybe I'll come back to this in a little while, but I have other projects that I've been itching to work on for a while. So one of those, which has been on the back burner for a few years now, is on the legacy of Privy Council judgments of the early to mid 20th century on post-colonial conceptions of legislative power. So this is something I've touched on before in some past work, but I think there's an interesting and underexplored connection between some of the limits imposed by the Privy Council on colonial legislatures and the way that translates to post-colonial judgments that find unwritten limits on legislative power, including through the unconstitutional constitutional amendments doctrine. So that's a big project that I'm turning to now.
That sounds very exciting. So thank you so much, Rehan, for joining me. And thank you, listeners and viewers, for joining us. So if you've enjoyed this discussion and you're interested in getting a hold of the book, we will put information about that below the video on the blog. And for more of the same, keep up to date with us by following us on X, formerly known as Twitter, or subscribing to our mailing list. And if you've recently published a book on constitutional law that you'd be interested in sharing with our audience, get in touch with us at our Gmail address or by contacting us on the blog's website. Thanks, Rehan.
Thanks, Lizzie.